So, Debo, as you stand in front of the Pettus Bridge in Selma, is thinking about where we are on the historical continuum the right way to conceptualize what the proper remedies are in the United States governmental machinery for redress for racial exclusion and discrimination?
So, Chris, here I go back to the Constitution. It begins by inviting us to make the Union more perfect. It's an aspirational document. It contemplates more progress. It contemplates the fact that the democracy must be tended to. And so as I stand here before the Edmund Pettus Bridge, and as Dale on the panel referred to the discrimination that was occurring right here in Dallas County, in Selma, Alabama in the 1990s, it seems almost denying reality to suggest that we can't encourage more progress and ask for it. We don't dishonor our progress by asking for more of it, and I think it's remarkable that the court would not look at cases like the McGregor case out of Alabama that we cite in our brief, where a federal judge in 2011 cites the last Supreme Court case interpreting the Voting Rights Act and says, look, it may well be that we've made progress in the South, but some problems in Alabama remain stubbornly the same, and he points to evidence in that case where members of the state legislature that sit today refer to African-American voters as illiterates and aborigines. And this was caught on a recording that the legislator himself was wearing as part of a sting.
Linda.
Well, in fact, I mean, we should point out that the Voting Rights Act itself contemplates progress. Because if a jurisdiction can show that for 10 years it has not had a Voting Rights Act violation, it, quote, bails out. And dozens of jurisdictions have bailed out, including, I think, 10 counties in Virginia, other jurisdictions in the South. And so it's not, it's sort of a badge of dishonor that these jurisdictions have to wear forever. They just have to behave themselves.
And on the flip side, if an uncovered jurisdiction misbehaves, it can get put in by a judge. It can be bailed in. And so this statute has its own tailoring, its own updating.
Built into it.
That's right.
And it's not frozen.
And Congress repeatedly has reviewed the legislation in reauthorization with thousands of pages of documentation.
But it does seem to me that there is the underlying thing here, and this comes out in the Grutter case on affirmative action, in which I think Justice O'Connor at the time, I think it's in her opinion, right, the majority of Grutter, I think she even says 25 years from now, we're not going to gives this time frame. There's a kind of underlying assumption in all of this, right? It's all moving towards some place where we can get rid of all this ugliness, all this sordidness. And I sort of wanted, the response to Scalia to be, maybe it will be in perpetuity. What exactly is wrong with that?
There's nothing. The 13th Amendment,
right? Exactly,
and the 14th and the 15th.
Right, exactly. Things can. I just think that the assumption that seems to frame all this discussion, particularly for the moderate swing, voters on the court like O'Connor before and Kennedy now, is this assumption that if it's not time limited in some way, if there's not some sort of horizon to which we're marching, then somehow that invalidates it. But it just seems to me that things that are good that prevent bad things from happening can just stay in place for as long as they stay.
As long as they're bad things.
Right, exactly.
You need laws to protect you from bad things as long as there are bad things happening.
Right, and one of the worst things she could have done was put that number out there.
25 years, right, exactly.
25 years, because people are counting down.
I know, literally, yes.
And unfortunately, in this case, you have Justice Roberts, who actually says, no, actually it's less than 25, because we have a black man in the White House.
Right.
So why do we need this any longer?
It's a preposterous thing to litigate, I think. Debo Adegbile with the NAACP's Legal and Education Defense Fund, who just argued for the defense in Shelby v. Holder and did an amazing job, joining us this morning from Selma, Alabama, which is commemorating the 48th anniversary of the historical civil rights march from Selma to Montgomery. Thank you so much. Linda Greenhouse, who covered the Supreme Court for the New York Times for 30 years. Dale Ho, member of the litigation team for the defense in Shelby v. Holder. Judith Browne Dianis of the Advancement Project, and Akhil Reed Amar of Yale Law School. That was really fantastic. Thank you much. I learned a lot. All right. Top Chef host Tom Colicchio joins us to talk about the intersection of food culture and hunger. That's next.